This is a very serious segment here. This is a very urgent segment here. The Missouri Independent, this is a commentary piece, but it's very well researched and well sourced. And so I want to read the lion's share of this. If courts fail to intervene, Missouri governor must halt the execution of Marcellus Williams. So Marcellus Williams is a death row inmate who was sentenced to be executed this Tuesday. And so there is a last minute push to postpone, if not outright cancel, the execution. This has already been delayed a number of times based on certain processes to try and get this overturned. Missouri plans to execute Marcellus Williams on September 24th. If that occurs, he'd be the 100th person executed in our state, Missouri, since 1989. A shameful milestone and another instance of executing a possibly innocent person. Williams has always professed his innocence in the 1998 murder of Felicia Gale Picus. The prosecution's case against him was based solely on notoriously unreliable, incentivized informant testimony and circumstantial evidence. No physical evidence or eyewitnesses implicated him. The current St. Louis County prosecuting attorney, Wesley Bell, tried to have the conviction overturned, but did not convince Judge Bruce Hinton following a hearing that there was sufficient evidence to overturn the conviction. However, there is plenty of evidence that the original prosecution was flawed and unfair. In a statement following Judge Hinton's ruling, Tricia Rojo Bushnell, executive director of the Midwest Innocence Project, emphasized Bell's office sought to vacate the conviction because, quote, there was overwhelming evidence his trial was unconstitutionally unfair. Retired St. Louis County Assistant Prosecutor Keith Larner, who oversaw the initial 2001 prosecution of Williams, testified at the August 28th hearing that on at least 5 occasions he handled without gloves the knife used to murder Gale Picus. Testing conducted in mid-August found the DNA of both Larner and Ed McGee, an investigator with the prosecution, on the knife handle. Attorneys for Williams and Bell argued this mishandling contaminated the weapon, potentially obscuring DNA evidence of the assailant and shutting a key evidentiary door, which could have helped exonerate Williams. Besides mishandling evidence, Williams' attorneys contended Larner's testimony helped prove he struck 6 of 7 African Americans from the original jury pool due to their race, leaving 1 black member on an otherwise all-white jury, thus denying Williams a chance to be tried before a jury of his peers. Race has always had a sordid history in the implementation of the death penalty in this country. Black people are disproportionately executed, 38 of 99 in Missouri, over 3 times the statewide population. And while African Americans have been about 60% of murder victims in our state over the past 5 decades, 78 of the 99 people executed were convicted of murdering white victims. Actually, yes, the racial disparity in death penalty cases is much more on the victim side than the perpetrator side. All murder is reprehensible, and Gale Picus's death was particularly gruesome as the assailant stabbed her more than 40 times. Police investigators found an abundance of physical evidence at the crime scene, fingerprints, bloodied shoe prints, and hairs, but none of it implicated Williams. Ultimately, prosecutors also unethically destroyed evidence, including lifted fingerprints, before his trial attorneys had the chance to have them tested independently. St. Louis County Police had no leads for 10 months following the murder until Dr. Daniel Picus, the husband of the victim, offered a $10,000 reward for evidence leading to the conviction of his wife's murderer. That's when Henry Cole called the police, claiming Williams confessed to the killing while the two were in jail together. A few months later, the St. Louis Post-Dispatch reported Laura Asaro was arrested for sex work. She told officers she had information about Gale Picus's murder, but when detectives tried questioning her, she refused, admitting she was, quote, just trying to get out of the arrest. Upon learning of the reward, though, Asaro then implicated Williams. Williams' attorneys contend the 2 witnesses' stories changed throughout the investigation, often contradicting their earlier statement and the facts of the crime. Both died several years ago. Their relatives have provided statements under oath reporting the two, both with extensive prior convictions and a history of drug use, were known for providing police false information to benefit themselves. Okay, so this sort of op-ed commentary piece in the Missouri Independent was sourced from this. This is the primary document by the PA, the motion to vacate or set aside judgment, and suggestions in support. So this kind of fleshes out a little bit more of this Lauren Asaro character. Hold on, I will get rid of our pesky logo there so I could read that properly. Asaro was not unknown to police. She had spoken with them before, both when facing charges of her own and when acting as an informant. And it wasn't their first time talking to her in relation to Ms. Gale's murder. On September 1st, 1998, after being arrested for prostitution, Asaro told officers that she had information related to the murder of the woman in U City. But when detectives arrived to question her, she would not talk to them, stating she was just trying to get out of the arrest. Police questioned her for 2 hours to no avail. Although Asaro was known to police after their interview with Cole on June 4th, 1999, police enlisted Cole as an informant for the next 4 months to try to make contact with Asaro. Detectives provided him with a pager so she could contact him, but Cole's efforts to get Asaro to incriminate Mr. Williams were unsuccessful. But police had another method of contacting Asaro due to her having several outstanding warrants. On August 5th, 1999, detectives visited Asaro in jail after an arrest and told her that the charges would be dropped if she cooperated. She was not receptive, so detectives then told her that Ms. Gale's husband had posted a $10,000 reward in the case involving the death of his wife, and she would be eligible for some or all of the money if she helped out. Asaro continued to deny, even after that reward was offered, that she had any information about the crime. By November 1999, police had not uncovered any information at this point that would corroborate what Cole told them. On November 17th, 1999, officers once again went to visit Asaro. Asaro, who was then working as a sex worker and using drugs, believed the officers were there to arrest her on outstanding warrants. The police offered once again to help Asaro with her warrants if she provided information about the murder of Ms. Gale. They told her she was guilty of withholding evidence if she did not cooperate. Okay, wow. So I want to go back to the beginning of this document just to read the sort of first part, the way this outlines everything, okay? Comes now the prosecuting attorney of the County of St. Louis and through special counsel for wrongful convictions, Matthew A. Jacober, and pursuant to section 547.031, moves to vacate or set aside the judgment by which the defendant, Marcellus Williams, was convicted of first-degree murder in the death of Felicia Gale. Mr. Williams received a sentence of death. Section 547.031 provides that the prosecuting attorney may move to vacate or set aside a conviction at any time if he or she has information that the convicted person may be innocent or may have been erroneously convicted. Here, DNA evidence supporting a conclusion that Mr. Williams was not the individual who stabbed Ms. Gale has never been considered by a court. This never before considered evidence, when paired with the relative paucity of other credible evidence supporting guilt, as well as additional considerations of ineffective assistance of counsel and racial discrimination in jury selection, cast inexorable doubt on Mr. Williams' conviction and sentence. On August 11th, 1998, Felicia Gale was found brutally murdered in her home. She had been victim to a violent and bloody crime. Her body was riddled with over 43 stab wounds. There was blood everywhere. Blood on the stairs, on the wall, near Miss Gale's body, and in the upstairs bedroom. The crime scene was rife with physical evidence. The weapon, a kitchen knife, was left lodged in Miss Gale's neck. Bloody shoe prints were present near a knife sheath in the kitchen, in the hallway leading to the front foyer, and on the rug near Mrs. Gale's body. Bloody fingerprints were found along the wall, and the hairs believed to belong to the perpetrator were collected from Miss Gale's t-shirt, her hands, and the floor. Here's the thing. None of this physical evidence tied Mr. Williams to Miss Gale's murder. Mr. Williams was excluded as the source of the footprints. Mr. Williams was excluded by microscopy, as the source of the hairs found near Miss Gale's body, which did not match Miss Gale or her husband, the home's only residents, and thus were presumably the perpetrators. And Mr. Williams was not found to be the source of the fingerprints. Now, 3 DNA experts have reviewed the DNA testing performed on the knife, and each has independently concluded that Mr. Williams is excluded as the source of the male DNA on the handle of the murder weapon. Miss Gale's murderer left behind considerable physical evidence. None of that physical evidence can be tied to Mr. Williams. Prosecutors are bound by the ethics of their office to inform the appropriate authority of after acquired or other information that casts doubt upon the correctness of the conviction. In this respect, public confidence in the justice system is restored, not undermined, when the prosecutor is accountable for a wrongful or constitutionally infirm conviction. So then the op-ed finishes, regardless of whether Judge Hinton could be convinced that there was enough evidence to conclusively prove Williams innocent, there is so much evidence pointing away from him and towards prosecutorial misconduct that Missouri executing him runs a huge risk of executing an innocent man. Moreover, Dr. Daniel Pikus, the husband of the victim, has opposed the execution. If courts fail to intervene, Missouri Governor Mike Parson must halt the execution of a man quite likely wrongly convicted. Okay, so we have some more materials, but we can stop there for a moment. I just have 2 very quick things to say, and then I'll toss to you. Number one, what is the upside of executing people exactly? Is it to satisfy some need for revenge amongst the population?
Yeah.
Like, what is the upside? Because it seems to me there's all downside. The only thing you do when you execute someone is you run the risk of making an irreversible mistake of killing someone who didn't do it, or in this case, who might not have done it. As the op-ed says, maybe there's not evidence here to conclusively prove his innocence, but of course the burden of proof is always on the state. It's always on the prosecution, which brings me to point number 2. It seems to be a pattern, the more we look into these criminal cases, of jurors not really understanding their responsibility under the law. When you are the juror in a criminal case, you don't vote guilty or not guilty based on whether you think the person is guilty or not guilty. You vote guilty or not guilty based on whether or not the prosecution has proved their case beyond a reasonable doubt. In other words, if you are leaning guilty, but you think there's reasonable doubt as to the defendant's guilt, you have a constitutional responsibility to, in that case, vote not guilty, even if you think there's better than 50-50 odds they are guilty. The standard is guilt beyond a reasonable doubt. The state must prove their case against someone if you are to lock them in a cage for years or for the rest of their life, or, and this shouldn't happen ever, I'm against the death penalty, kill them. Like, that is the responsibility of a juror. And it seems at the very least here, you could say there is nowhere near proof beyond a reasonable doubt that this guy is guilty of murder.
Yeah, I read a book sometime back. It was all cases that the Innocence Project was working on. That it was called Actual Innocence. And they really got into what these prosecutors do, and it's horrifying. They will bring people in, and they'll just lead them around to the suspect they want them to choose. Look at this picture. Are you sure that's not the person you saw?
Right.
Are you sure that's not the person you saw? Well, it might be the person I saw. Okay, so you're saying it's the person you saw. And in spite of what...
Well, there's a Sorrow woman. They went back to her, what, 3 times?
Right.
It looks like,
right.
yeah.
You have to remember.
They offered money. That didn't work. Then they offered to hold her in contempt or whatever. You will be guilty of withholding evidence, whatever the charge was. I forget. I'm sorry.
Yeah,
Go ahead.
it's not like an episode of Law and Order. That's not how it works in real life. In real life, these cops and these prosecutors are trying to make cases because this is their profession. That is how they advance in the ranks, particularly prosecutors. In a case like this, it's going to be prosecuted by the DA's office. And a lot of those people, if not most of them, are looking ahead to private practice. They're looking ahead to making the real money as high paid defense lawyers. And how do you get that? By racking up cases, by showing that you're a winner. Insofar as they evaluate any kind of ethics behind what they're doing, well, that's on the defense attorney to mount an adequate defense. Now, I'm not going to say all prosecutors will go beyond the law, but what I will say is nationwide, we know this is a problem. They'll stack charges on people so that they won't even go to court. Now, yeah, you're facing 50 years in prison.
Right.
Or you could plea it down. Are you going to risk it?
Exactly.
Are you going to take the chance? That happened with the Newberg case that we covered. Most
in that case they didn't take the deal, but yeah, they offered them a reduced sentence.
Well, that's what I'm saying. They stacked up the charges and they refused to take the deal. But most people will take the deal because, man, I would probably take the deal if you're telling me you're going to face 50 years. I know how corrupt the justice system is. And particularly, I'm sorry, in spite of what Matt Walsh might believe, yes, there is systemic racism. It is not an accident that the core, most valid manifestation of critical race theory grew out of an analysis of the disparities in the criminal justice system. It was originally an effort to explain why you can change the law to eliminate discrimination from the legal code and yet wind up with these unequal results that you're talking about. If you want to talk about the death penalty, you can't even begin to talk about the death penalty until you get rid of that disparity. And and then beyond that, you would have to have a perfect justice system because you're talking about something that's so irreversible and so horrific to do to somebody who's innocent. And this is something we don't like to talk about. But if you start researching this, we've executed a lot of innocent people, certainly executed a lot of innocent people. And this is, God forbid, about to be one of them, it seems.
Yeah. Well, there's a call to action at the end of this, and that's attached to a piece that the Innocence Project just put out 2 days ago. For the third time, Marcellus Williams faces execution, the grim reality unfolding. So this is emotionally kind of tough to take, but this is how we go about executing people in this great freedom-loving country of ours. Notably, Missouri has executed several people before all of their appeals were technically done. The pentobarbital used by the state of Missouri was banned for use in executions by the manufacturer, but the state is still able to get the drug. The majority of pharmaceutical companies have stopped supplying drugs for use in executions after years of pressure from advocates. As supplies have become less available, states have illegally imported drugs across state lines, and some states, including Missouri, have purchased the drugs from compounding pharmacies, which formulate drugs that are not available at commercial pharmacies. Compounding pharmacies are not required to register with the FDA or inform the FDA of what drugs they are making. Missouri buys the drugs used for their executions in cash from an unknown source. Sounds like something Joe Biden would throw a black guy in jail for in the 90s, right?
Yep.
Hey, we're paying in cash for this unregulated substance.
Yep.
All right. Mr. Williams has repeatedly faced imminent execution as he has tried to prove his innocence. September 24th will be the third time that Mr. Williams has faced execution. In 2017, mere hours before he was to be executed and after eating his last meal, then Governor Eric Greitens granted a stay of execution. Despite the fact that the victim's family opposes his execution, the Missouri Attorney General has continued to fight to execute Mr. Williams at every turn. It is not too late for Governor Parson to ensure that Missouri does not take an innocent man's life. The governor should exercise his authority to grant clemency and commute Mr. Williams' sentence to life without parole, or at a minimum, stay the execution to allow the resolution of further appeals. So the Innocence Project tweeted this out here. This is it. We only have 2 days to stop Missouri from executing Marcellus Williams, an innocent man. Though Governor Parsons' office is closed today, that's Sunday, we can't let a single moment go where we're not urging him to take action. Email, tweet, and contact his office now. And so they put the phone number for you to call. Take a screenshot of that, folks. Write that down. Call that number. Let's get, 50,000 of our loyal DueDissidence audience to leave some voicemails there. Email and tweet by visiting savemarcellus.org and share this post far and wide. That's on our Twitter. I will pin that to the top of our profile, actually, to make sure everybody can find that. So you can go to our Twitter and find that post. I'm actually going to do that right now. Meant to do that before the show. Here we go. Pin.
This is, these are truly dark times. People often ask what they can do to make a difference, what you can do that's positive. Here is something that you can do. This man, based on the information we just shared, is almost certainly about to be executed for a crime that he did not commit. Just imagine being in a position like that. Imagine being in this man's situation. Take you 2 minutes to make a phone call, less than that to email or tweet, but do something to put pressure on this governor's office to let them know people are watching.
Yes. Yeah, absolutely. I don't know if you can pin a repost, but I just unreposted and re-reposted. So that should be at the top of our profile now if you need it. But take a screenshot on your phone, do whatever you got to do, get that number down and make the call. Yeah, no, look, extremely dark times. It's just such an ugly thing to do. It's just such an ugly thing in general. I mean, again, what is the need for it? Why? Why does the state have to kill people? Why can't you just, if someone is a danger to society, we are supposed to have jails to protect the population from dangerous people. You're not supposed to have drug users in jail. You're not supposed to have nonviolent criminals in a cage. It's just a barbaric thing. Sometimes you talk to people and, like we interviewed a prison abolitionist on the show long time ago, way before this was a video show. And, people like prison abolitionists, you look at them, and when they say we need no prisons at all, you think, well, that's radical, that's extreme. And maybe in a literal sense it is, right? I mean, Charles Manson, what were we supposed to do with him? Just let him walk the streets? Or somebody like that, right, who wasn't CIA-backed. Haha. Just kidding.
Should have given him a record contract.
Yeah, should have given him a record contract, exactly. So
would have avoided a lot of trouble.
But one of the things that when you talk to a prison abolitionist, even though their ideas may sound extreme on the at the outset, and maybe in a literal sense, even if they are, when you talk to someone who says, hey, we should actually strive towards a world without prison, in talking to a person like that, it gives you a great perspective as to just how extreme an act it is to put someone in prison, how extreme an act it is to take someone away from their family, out of society, lock them in a cage for years and years and years for doing not much of anything at all. I mean, Joe Biden's crime bill, you have people serving years and years in prison for nonviolent drug crimes.
Right.
That's not extreme. Like, that's more extreme than prison abolition. I think locking someone in a cage for snorting crack cocaine for 10 years, that's a much more extreme idea than saying we should just do away with prisons altogether. Much more, not even close.
Well, sure. That's why I've never had any patience for self-proclaimed liberals pumping up Joe Biden or even voting for Joe Biden while screaming Black Lives Matter. No one, or Kamala for that matter, I've said many, many times, I challenge you to name one living and active politician who has done more real world harm to Black and brown communities than Joe Biden. One who is still active. One. And nobody has ever been able to come up with a name because there is not one living and active politician who's done more real damage to those communities. And you're going to have Black Lives Matter in your profile and go Joe Biden. And yes, Kamala Harris, she hasn't been around as long as that old fucking senile mummy. But she's done her share of damage with locking up people on marijuana charges. Very similar to this, fighting not to exonerate a man who DNA evidence would clear, fighting not to have the DNA. Why would you? What's the logic behind that? Of not examining the evidence? What if he's innocent?
No,
why
would you
fight not? That's what I'm saying. They want the win. It's not Law and Order. It's where you have these conscientious prosecutors. God damn it, Jim! I think he's innocent. It's not like that. They're racking up that your life is a notch on their belt. That's
exactly. Yep. It's a win-loss column so that when they decide to run for office, they can point to this great record of keeping the people safe from the scary people who we put in jail for no reason. Yeah, absolutely. That's the way it is. So once again, just to put a button on this segment, we'll put the number up again. That is the governor's office. That's a public number. Call, leave a voicemail, email, tweet, whenever you can. Get it done.
Please clap.